Hello, everyone, and welcome to another presentation on the laws of the Bahamas, where we will be discussing real estate transactions. As always, make sure to subscribe to our YouTube channel or your favorite social media platform. And please, feel free to hit that like button if you have enjoyed our video. So let's begin. So if you're tuning in, chances are you are either thinking about purchasing property in the Bahamas or about to start the transaction process. Here are some key points when dealing with real estate transactions. The first point deals with understanding what land ownership in the Bahamas actually means. The concept of owning land in the Bahamas is far different than owning any other asset, such as cars, boats, and your favorite television set, for example. While there is no doubt about the complete ownership of these items, when it comes down to land ownership, the laws of the Bahamas does not recognize absolute ownership of land, unless it is in the hands of the Crown. The greatest interest in land that a person can have is what is legally referred to as an estate in fee simple. This is an ancient term which presumes absolute ownership of land by a royal monarch, and the subjects of the monarch simply hold an interest in the land. So an estate in fee simple refers to feudal ownership of an estate by a lord as a result of some kind of service, to which the estate can be inheritable by blood relations, used as collateral, or otherwise subject to the laws of succession. Now, this term goes all the way back to the colonial history of the Bahamas, and while we are an independent nation, the old system of land ownership remains. Under Bahamian law, the King of England is the supreme owner of every parcel of land in the Bahamas, and all land is held directly or indirectly of the monarch. This is seen when investigating the title of land, for example, where in theory, the title of every parcel of land in the Bahamas originates from the Crown, which is later transferred from one landowner to the next in fee simple by a legal instrument such as a Crown grant, a conveyance, deed of gift, etc. So whenever you hear the term clean title, this primarily refers to either an unbroken record of previous ownership of the property that can be traced back to the Crown, or at least within the past 30 years, or in cases where there is an order by the Supreme Court, where the title of the property is either quieted or adversely possessed. Now, the second point to remember is don't go into the transaction blinded. You'll be surprised at the number of persons who enter agreements to purchase property here in the Bahamas without speaking to either a real estate agent or an attorney, as a way of either saving on cost or simply not wanting to deal with it. Most people don't realize they are taking a very high risk when jumping into agreements without proper representation, which often leads to spending more fees on either to close a transaction or to correct certain errors in order to make the property marketable for purchase. They rely on whatever the vendor tells them, not knowing that they'll be headed for a major headache. Many don't realize that each transaction is unique in its own right and should be treated on a case-by-case basis, which is primarily due to the fact that the Bahamas does not have a land registration system like other countries. So a lot of time is spent on researching the property's title before the transaction is complete. Now, this is where your realtor and attorney comes in. They are the starting point in these matters. Realtors are known for locating a buyer to purchase land, or in this case, locate a suitable property for their buyer. But when it comes down to closing the sale, realtors pay attention to the finer details in the property, from structural imperfections on the property to outstanding taxes and utility bills, which may affect the transaction. For the most part, Real property taxes and utilities are tied into the property and not the owner. So if a property transaction closes before any outstanding bills are satisfied, you will be stuck with it. A good agent will use these factors to properly advise their client and use it to their advantage in negotiating a more favorable purchase price. And that's just a mere sample of what they do. So if you think that the realtor you've hired is getting paid for doing nothing, then you might want to reconsider your position. So think of your realtor more like a project manager or an organizer. They're the ones that will introduce you to an attorney if you don't have one and recommend other professionals that will be needed to close the sale. And for non-residents or locals who are unfamiliar with the location of the property, your realtor should be able to advise you on property that is suitable for your taste. Take for an example, non-residents who see a property on sale for a very attractive price, only to be disappointed when realizing that the location isn't exactly what they had in mind. A good realtor is going to save you a lot on disappointment in explaining the lay of the land, so to speak. So when dealing with attorneys in real estate transactions, these individuals play a key role in drafting, reviewing, and recording conveyances. But more importantly, the attorney ensures that the property is free and clear of encumbrances, which is done by providing a legal opinion after conducting a title search to confirm that the owner has a clear line of title to the property and ensures that the vendor is not subject to any outstanding court judgments or pending legal action which may interfere with the transaction, which is usually done by a causeless search. This is where a lot of property transactions become more or less complicated. And if your attorney sees either a gap in the property's title or if there is a pending judgment that is detrimental to the transaction, the attorney has to resolve the issue before the scheduled closing date for the sale. So if the property is sold without resolving these issues, you're going to be the one stuck with the bill, which may or may not affect your ability to transfer the property or using the property as collateral, or even losing ownership of the property by the courts. So you can see where things can get a little tricky in failing to get the right assistance in these matters, which brings us to our third point when dealing with real estate transactions in the Bahamas, which is simply to know exactly what you're buying. Just because you had a tour of the property doesn't mean that it magically appears on the deed. So it is even more important that you retain the right professionals for the job. Believe me, it is very easy to enter an agreement where what you see isn't exactly what you're getting. There are many horror stories of purchasing land with incorrect dimensions or inaccurate locations. And in worst case scenarios, property with multiple purchases or land that simply does not exist, only on the paper that is drafted on, otherwise known as paper property. These issues can be missed very easily if you decide to proceed without assistance. So to avoid this, you may require the services of either a licensed surveyor or an appraiser, depending on whether it is needed in the transaction. Surveyors are responsible for providing the proper dimensions of the property and drawing up a survey plan, both of which is needed for the sales agreement and conveyance deeds, while appraisers focus on assessing the value of the property in the provision of an appraisal report, which is required when registering the property with the Department of Inland Revenue, who is responsible for assessing the value of the property and applying the appropriate value-added tax and real property taxes if necessary. So as a purchaser, you should always be prepared to retain an appraiser when buying property here in the Bahamas, as the vendor may have an outdated report or none at all. If a survey isn't available, your realtor or attorney may negotiate the purchase price to cover the cost of any outstanding documents needed to close the sale. This brings us to another important feature of real estate transactions in the Bahamas, which is our fourth point, and that is to know the costs. You should always be aware of the expected closing costs and how fees are structured. For those first-time buyers, you should always be aware of the difference between a gross sale and a net sale before entering agreements. This is important in determining which party is responsible for paying VAT and stamp duty, which has a rate of 2.5% on properties valued at $100,000 and under, and 10% on properties valued over $100,000. For realtors, the minimum rate sales commissions are 6% of the sales price of developed property and 10% for undeveloped land, while attorneys normally charge a rate of 2.5% of the purchase price, with nominal fees for title and costless searches and recording of the documents. For non-residents, there is an application fee to obtain approval from the Bahamas Investment Authority at a fee of $250 for owner-occupied property and $500 for vacant land. Anyways, that's our show for today. If you want to watch more of our videos, you can always visit the Lex Justice Chambers YouTube channel or visit our website at www.BahamaLawyer.com for more information on the laws of the Bahamas. We thank you for watching, and we hope to see you again in our next presentation.